United States v. Bland is a 1972 case. Wilkie Circuit Judge gave the opinion. The United States, as statutory appellant, seeks review of a memorandum opinion in order of the United States District Court and the District of Columbia holding 16 D.C. Code Section 2301(3)(a) unconstitutional as an arbitrary of the presumption of innocence. Section 2301(3)(a) provides a child term, meaning the term child means an individual who is under 18, except that the term child does not include an individual who is 16 years of age and older, and A, charged by the United States attorney with 1, murder, forcible burglary in the first degree, robbery while armed, or assault with intent to commit any such offense, or 2, an offense listed in Clause 1 and any other offense properly joinable with such an offense. Appellee was 16 at the time of his arrest and indictment on charges of armed robbery of a post office and related offenses. He moved to dismiss the indictment for lack of jurisdiction and assertion of the statute to prosecute him as an adult violated the Constitution because it denied him procedural due process. Okay. Congress, pursuant to its constitutional authority to exercise exclusive jurisdiction over the District of Columbia, created the Family Division of the Superior Court of the District of Columbia. Created the Family Division of the Superior Court of the District of Columbia. In defining the jurisdiction of the Family Division, Congress conferred on it exclusive jurisdiction of proceedings with a child in which a child, as defined in 16-2301, is alleged to be delinquent, neglected, or in need of supervision. Next page. Division's justice extends over a person, a child alleged to have committed delinquent acts, a child being classified as a person not having reached the chronological age of 18 and not charged by the United States with certain specified crimes. As to any other individual, either one who has reached 18 or has reached the age of 16 and has been charged by the United States attorney with one or more of the enumerated felonies, he is not a child and is to be prosecuted in the regular adult court system, whether it be the D.C. Superior Court or the United States District Court. The legislative history accompanying the 16 D.C. Code 2301 reveals Congress's intent in enacting this legislation to improve the operation of the juvenile justice system in the District Court of Columbia by removing from its jurisdiction certain individuals between the ages of 16 and 18 whom Congress concluded were beyond rehabilitation. I guess this is the legislative interest in the designation. They're substantiating by 1, individuals are beyond rehabilitation in the juvenile justice system, and 2, whose presence in that system serves a negative influence on other juveniles. This represents a policy judgment of Congress after gathering extensive, appropriate evidence as to how persons should be classified as adult and child for the purposes of rehabilitation following the commission of a criminal offense. We note that the policy judgment was both negative and positive. Some previously classified as juveniles were beyond rehabilitation. Others of the same chronological age were susceptible to special juvenile treatment and for any chance of success, these latter should be protected against the hardcore repeat offenders of the same chronological age. While Congress easily could have established 16 as the cutoff date, it is not clear what constitutional infirmities our dissenting colleagues would have found in that less sympathetic approach. It concluded that some within the 16 to 18 age bracket were susceptible of rehabilitation, and determined that those 16 and 17 whose offenses charged were minor were to be included within the juvenile system. Okay, so the Senate Committee of the District of Columbia, by revealing its rationale for excluding such persons from the jurisdiction of the Family Division, stated the committee has concluded that a juvenile can reliably be considered too well-formed or sophisticated for and beyond the reach of mere juvenile therapy, and the particular juvenile has already been exposed in years of relative discretion to the juvenile system and treated to the extent that his case required, as suggested by a prior finding of delinquency, and has nevertheless returned to serious misconduct, as suggested by a serious felony charge. The House Committee on the District of Columbia gave the following as the basis for its exclusion of the 16 years of age or older charged with certain serious crimes from the Family Division's jurisdiction, as follows. So here's a little bit more rationale. Because of the great increase in the number of serious felonies committed by juveniles, and because of the substantial difficulties in transferring juvenile offenders charged with serious felonies to the jurisdiction of the adult court under the present law, provisions are made in this subchapter for a better mechanism for separation of the violent youthful offender and the recidivist from the rest of the juvenile community. As finally enacted, Section 2301 reflects a compromise between the initial Senate and House versions. It provides the Family Division shall have jurisdiction over persons under 18 except those 16 and older charged ... with murder, forcible rape, robbery while armed, burglary in the first degree, or assault with intent to commit one of the offensive or any such offense, and a properly joinable offense. The district court found this invalid as violative of the due process law. The determination that a child should be tried as an adult cannot be made without the safeguard of basic due process. Without a provision in the new statute that would require some determination reached after a fair hearing that an individual is beyond the help of Family Division, the statute must fall as violative of due process. So it doesn't have a safeguard of due process, but what kind of due process? A fair hearing? That an individual... Okay, so the determination that an individual is a recidivist is gotta be supported, and the statute lacks support for that determination, which otherwise determines their venue, their fate. So I think that's the problem that they're finding. As the discussion on the legislative background indicates, Congress was well acquainted with the problems confronting the juvenile justice system in the District of Columbia. Logically, its definition of the Family Division's jurisdiction reflects its particular concern with the rise in the number of serious crimes committed by those 60 years of age, and were coupled with the growing recidivist rate among this group. Secondly, legislative exclusion of individuals charged with certain specified crimes from the jurisdiction of the juvenile justice system is not unusual. Several states have similarly excluded certain crimes in defining the jurisdiction of their respective systems of juvenile justice, while others vest concurrent jurisdiction over enumerated crimes in both their adult and juvenile courts. So this is not an uncommon distinction among the states. Or their approach. The disagreement of our dissenting colleague arises almost solely from his fundamental unwillingness to accept Congress's power to define what is a child. The words child, infant, or minor from early times in various legal systems has been susceptible to definition by statute. And critical age for specified purposes has varied and differed between male and female. Before 1970, the District of Columbia Code defined child as a person under 18 years of age. Our dissenting colleague seems to consider the statute and its definition immutable, apparently because it was involved in Kent versus United States. We accept the fact that Congress has abolished the statutory definition and by statute substituted another to which we simply give full effect. Believing that Congress has power to amend a statutory definition, we start with the definition of child concurrently on the statute books and reach the legal conclusions set forth herein. Similarly, next page, the appellate's argument on the alleged waiver of the jurisdiction of family court is based on the now outmoded definition. The District of Columbia Code states clearly that the jurisdiction of the family supervision of the Superior Court in delinquency cases is limited to those who come in the statutory definition of child. Until it is determined whether a person is a child within the statutory definition, there is no jurisdiction. Therefore, a fortiori, there can be no waiver of jurisdiction. Nor is it true a suspected juvenile remains a child until he is charged with an enumerated offense by the United States Attorney. There is just no classification of the person as a child or an adult until 1, his age is accurately ascertained, and 2, the decision on prosecution is made. Congress has incorporated more than one element in the definition of a child. Until all elements of the definition are ascertained, the status of a child is simply uncertain, just as under the 1967 definition, as the status of a person would be uncertain until his true age was established. The district court's finding in the case at bar and appellee assertion to the same effect that the exercise of the discretion vested by the statute number 2301 in the United States Attorney to charge a person 16 years of older with certain enumerated offenses, thereby initiating that person's prosecution as adult, violates due process, ignores the long and widely accepted concept of prosecutorial discretion, which derives from the constitutional principle of separation of powers. The Fifth Circuit, in holding a court had no power to compel a United States attorney to sign an indictment, stated, although as a member of the bar, the attorney for the United States is an officer of the court, he is nevertheless an executive official of the government and is, as an officer of the executive department, that he exercises discretion as to whether or not there shall be prosecution in a particular case. It follows as an incident of the constitutional separation of powers that the courts are not to interfere with the free exercise of the discretionary powers of the attorneys of the United States in their control over criminal prosecutions. While there may be circumstances in which the courts would be entitled to review the exercise of prosecutorial discretion, these circumstances would necessarily include the deliberate presence of such factors as race, religion, and other arbitrary classification not found in the case at bar. For example, in the Absence of such factors, the court has held that the exercise of prosecutorial discretion, even when it results in different treatment of co-defendants originally discharged in the same case with the same offense, does not violate due process or equal protection of the law. Next page. The district court and appellee in the case at bar point to the acknowledged sufficient effect of the United States Attorney decision whether to charge an individual 16 years of age or older with a certain enumerated offense, and conclude that in the absence of a hearing, due process is violated when such a decision is made. This, however, overlooks the significance of a variety of other prosecutorial decisions. Example, whether to charge one person but not another possible co-defendant, whether to charge an individual with misdemeanor or a felony, etc. Furthermore, the decision whether to charge an individual with a misdemeanor or a felony has long determined the court in which that person will be tried. We cannot accept the hitherto unaccepted argument that due process requires an adversary hearing before the prosecutor can exercise his age-old function of deciding what charge to bring against whom. Grave consequences have always flowed from this, but never has a hearing been required. Judicial consideration of the legitimate scope of prosecutorial discretion clearly encompasses the exercise of such discretion where it has the effect of determining whether a person will be charged as a juvenile or as an adult. In the absence of such suspect factors as race, religion, or other arbitrary classification, the exercise of discretion by the United States Attorney in the case at bar involves no violation of due process or equal protection of the law. The district court and appellee assert that the exercise of discretion violates due process in that it denies the individual charged with the presumption of innocence. The presumption of innocence, as the Supreme Court has long held, applies to the prosecution at trial and is a conclusion drawn by the law in favor of the citizen by virtue whereof, when brought to trial upon a criminal charge, he must be acquitted, unless he is proven beyond reasonable doubt to be guilty. The United States Attorney's decision in the case at bar marks only the beginning of the process of adjudication of appellee's guilt, process marked by the presence of the traditional protections of procedural due process, followed by the extraordinarily liberal rehabilitative provisions of the Federal Youth Corrections Act. For these reasons, the order of the district court dismissing appellee's indictment on the basis of its opinion holding 16 D.C. Code Section 2301(3)(a) unconstitutional as an arbitrary legislative classification and as a negation of the presumption of innocence is accordingly reversed, and the case is remanded for trial. So this is kind of the end of the majority opinion at 18 minutes. I'm going to start with the dissenting opinion discussed in the majority opinion. Skelly, Wright, Circuit Judge, dissenting. As a matter of abstract legal analysis, the opinion of my brother might appear to some degree persuasive, but we do not sit to decide questions in the abstract, and we are not writing on a clean slate. In 1966, the Supreme Court spoke clearly and specifically about this area. See Kent versus United States. It held in unmistakable terms that before a child under 18 can be tried as an adult, in adult court, the Constitution requires a hearing sufficient to the particular circumstances to satisfy the basic requirements of due process and fairness. I had not supposed that it was within our power as a lower federal court to change this mandate, nor had I imagined that Congress could overrule this constitutional decision by a simple statutory enactment. Yet the majority holds that whereas before passage of the Court Reform Act in 1970, the Constitution required a hearing, after its passage, the Constitution requires no such thing. Before 1970, the District of Columbia Code defined child as a person under 18 years of age and granted original exclusive jurisdiction to the juvenile court for the trial of children. Thus, initially, any person under the age of 18 was to be tried in juvenile court. It did not necessarily follow, however, that such a trial always took place. The juvenile court was permitted to waive jurisdiction over a child 16 years of age or older who was charged with a felony, or over any child charged with a crime punishable by death or life imprisonment following a full investigation. Matters stood at this point when, in 1966, the trial court considered the statute in its landmark Kent decision. The court began its analysis by observing that the waiver decision was vitally important to the accused, that, indeed, it could potentially mean the difference between a few years' confinement and a death penalty. In light of the obviously crucial nature of these rights, the court affirmed the requirement of access to social records and assistance of counsel during waiver proceedings, but it also held that the statute, when read in context of constitutional principles relating to due process and the assistance of counsel, required more. Specifically, the juvenile was entitled to a hearing and to a statement of reasons for the juvenile court's decision. Thus, during the period immediately after Kent, juveniles were afforded a wide range of procedural rights in connection with the waiver proceedings. So matters stood until 1971 in conjunction with sweeping legislation to reform the District of Columbia judicial system. Congress made some innocuous sounding changes in the juvenile court's jurisdiction. The new legislation retained the basic waiver mechanism, although the statute now explicitly provided for a hearing and a statement of reasons, and established some standards to guide the judge in making waiver decisions. Similarly, the new statute continued to grant exclusive jurisdiction to the family court for proceedings in which a child, as defined in Section 16-2301, is alleged to be delinquent. But whereas previously a child had been defined to include all persons 18 years of age or younger, the new code accepted from the definition an individual who is 16 years of age or older and charged by the United States Attorney with murder, forcible rape, burglary, and first-degree robbery while armed, or assault with intent to commit such an offense, or 2, an offense listed in Clause 1, and any other offense properly joinable with such an offense. As a moment's reflection makes clear, the so-called definition, in fact, establishes a second and parallel waiver procedure whereby a juvenile can be transferred from the family division to adult court. The government chooses, it may institute waiver proceedings in family court in an attempt to convince the judge that, under the standards enunciated in the Act, the child could more appropriately be tried in adult court. It would be surprising if this procedure were much utilized in cases covered by 16 D.C. Code Section 23013A. However, since under it, the government must observe the procedural rules mandated by Kent. Moreover, there is always the possibility that the government will not carry its burden before the family court judge, in which case the waiver attempt would fail. These risks and inconveniences can be avoided by following the second alternative. The prosecutor simply charges the juvenile with one of the enumerated offenses. The juvenile ceases to be a child, and hence the family court is automatically divested of jurisdiction. Thus, if the prosecutor follows the second alternative, the waiver decision becomes his alone, and he is permitted to make it without the encumbrance of a hearing, the requirement that he state reasons, the inconvenience of bearing the burden of proof, or the necessity of appointing counsel for the accused. I think it obvious that this second procedure was written into the Act in order to countermand the Supreme Court's decision in Kent. Indeed, the House committee primarily responsible for drafting the provision virtually amended as much. The committee report explains 16 D.C. Code Section 23013A as follows: because of the great increase in the number of serious felonies committed by juveniles, and because of the substantial difficulties in transferring juvenile offenders charged with serious felonies to the jurisdiction of the adult court under the present law, provisions are made in this chapter for a better mechanism for separation of the violent youthful offender and recidivist from the rest of the juvenile community. While the surface veneer of legalese which encrusts this explanation need fool no one. A simultaneous translation into ordinary English might perhaps prove helpful. The substantial difficulties under present law to which the committee coyly refers are, of course, none other than the constitutional rights refers to encourage those of us still committed to constitutionalism and the rule of law. This blatant attempt to evade the force of the Kent decision should not be permitted to succeed. The result in Kent did not turn on the particular wording of the statute involved or on the particular waiver mechanism where employed. Rather, as the court itself made clear, the rights expounded in Kent are fundamental and immutable. All right, looking at like 3 more pages of notes. The issue in this case is not whether the prosecutor should be permitted to make waiver decisions, but rather how he should go about making decisions. Put slightly differently, the question is whether the shift in decision-making responsibility from the court to the prosecutor eliminates the need for the procedural rights expounded in Kent. I would, of course, answer that question no. The transfer of the waiver decision from the neutral judge to the partisan prosecutor increases rather than diminishes the need for due process protection for the child. In answering the question, yes, the government and the majority here rely on essentially 3 lines of argument. Although these contentions are interrelated, the purpose of analysis, they are best addressed seriatim. S-E-R-I-A-T-I-M. Seriatim. The government first argues that the Kent decision should be limited in situations in which the government attempts to redact some pre-existing right, and that this is not such a situation. As the government reads Kent in holding is restricted to cases where the family court had exclusive just really bumping this up against Kent. So I'm writing that down. Kent's holding. They're reading Kent's holding is restricted to the case where the family court has exclusive jurisdiction ab initio and the prosecutor attempts to wrest this jurisdiction from it. After passage of the Court Reform Act, it is argued the family court is no longer vested with the exclusive jurisdiction over persons between 16 and 18 who are suspected of committing serious felonies. Rather, the government contends this jurisdiction is now concurrent, and the U.S. attorney is vested with the authority to determine the forum in which to proceed. Since there is no longer a pre-existing right to juvenile treatment, there is no longer a necessity to observe the procedural formalities which under Kent must accompany divestiture of such a right. Despite the superficial plausibility of this argument, I think it plainly fallacious. In in the first place, I can find nothing in Kent which speaks to Platonic distinctions between divestiture of a existing right and failure to grant a right not already in existence. Kent rested not on some fine point of metaphysics, but on the crucially important for children in an adult court, and that granted them and family court. Of course, that distinction is not as important whether the selection of the adult form is spoken as the divestiture of an existing exclusive juvenile jurisdiction or as the initial choice of a concurrent adult jurisdiction. In either case, the consequences to the child are precisely the same, and hence the procedural protection should be identical. Moreover, even if one accepts the dubious divestiture distinction as relevant, the government's argument simply does not fit the contours of the statute. It is not true that the U.S. Attorney decision to proceed in adult court negates no pre-existing right, or that the decision to proceed in court negates no pre-existing right, or that the family court lacks exclusive jurisdiction ab initio. In fact, the basic jurisdiction statute remains, for our purposes, unchanged since the Supreme Court's decision in Kent. Now as then, the juvenile court is in terms granted exclusive jurisdiction over all children as defined in 16 D.C. Code 2301. True, the definition of child contained in 16 D.C. Code 2301 is now modified, but under the new definition, a suspect juvenile remains a child until he is charged with an enumerated offense by the United States Attorney. It follows that under 11 D.C. Code 1101, the family court retains exclusive jurisdiction under the United States Attorney until the United States Attorney ends the defendant's status as a child by charging him with an enumerated crime. Thus, the United States Attorney charge acts to divest the juvenile court of its pre-existing exclusive jurisdiction. So this is totally a jurisdiction argument. And due process being that convictions. So they're trying to say that minors should be considered innocent until proven guilty. Where did I just sentence? Waivers? No. Thus, the United States Attorney charge acts to divest the juvenile court of jurisdiction in precisely the same manner as does the juvenile judge's waiver decision. Since the divestiture is the same, the procedural rights accompanying it should be the same, and we need look no further than Kent to determine what those rights are. The majority wisely eschews substantial reliance on the government's divestiture argument to distinguish Kent, but instead, my brethren adopt two other arguments which to me at least seem equally unconvincing. First, the majority seems to contend that Kent is inopposite because it applied to a judicial decision, whereas 16 D.C. Code 2301 contemplates a prosecutorial decision. The decision by a juvenile judge or by the United States Attorney to treat the child as an adult marks the beginning of precisely the same process of adjudication, and it cannot be doubted the United States Attorney is certainly a less disinterested decision maker than the juvenile court judge. It would seem that in order to compensate for lack of neutrality, procedural niceties, that's right, that's where we are. Okay, procedural leader is the decision maker. It should be clear then that the test for when the Constitution demands a hearing depends not on the government official makes the decision, but rather on the importance of that decision to the individual affected. The extent to which procedural due process must be afforded is influenced by the extent to which an individual may be condemned to suffer grievous loss. The test is not a precise one, and reasonable men may differ as to its application in close cases, but at least the underlying requirement is clear. Certain principles have remained relatively immutable in our jurisprudence. One of these is that where governmental action seriously injures an individual and the reasonableness of the action depends on the fact findings, the evidence used to prove the government's case must be disclosed to the individual so that he has opportunity to show that it is untrue. Finally, the government argues that the extension of Kent to prosecutorial waiver doctrine and prosecutorial discretion. It is, of course, still widely believed that prosecutors have a broad unreviewable discretion to determine which offenders to charge and what crimes to charge them with, although this notion is now widely challenged by the leading scholars. But it should be readily apparent that usual notions of prosecutorial discretion have nothing to do with this case. The defendant does not ask us to review the substance of the prosecutor's merits of the decision ultimately reached. I think it plain here that the prosecutor's broad authority to choose between juvenile criminal procedures provides no argument for the power to exercise that authority in a manner which does not comport with prosecutorial due process. My brothers point to the significance of a variety of other common prosecutorial decisions, misdemeanor or felony. Grave consequences have always flowed from this, but never has a hearing been required. As the majority itself indicates, there are dramatically real differences between run-of-the-mill Charging decisions and prosecutorial waiver of family court jurisdiction. A normal charging decision is only the beginning of the process of adjudication of defendant's guilt, a process marked by the presence of all the traditional protections of procedural due process. The defendant has the opportunity to show that he was improperly charged. That is, that he is not guilty at the preliminary hearing, at the trial itself, and if necessary, on appeal. In contrast, the waiver decision marks not only the beginning but also the end of adjudication as to child's suitability for juvenile treatment. It is well established that, barring equal protection problems, a guilty person has no right to be charged with a criminal offense, but a guilty child may, under certain circumstances, have a right to be charged as a juvenile. The question of juvenile treatment turns not on the issue of guilt, but on such factors as the maturity of the child and his susceptibility to rehabilitation. These factors, unlike the question of guilt, drop out of the case once the individual waiver decision is made. Hence, it is especially vital that the procedures be fair at the one point of the criminal process where these matters are considered. The very fact that the prosecutor's decision is largely unreviewable and therefore final argues for rather than against making certain that he has all the facts before him for the trial of criminal offenses. The family court is more than just another judicial body. It is another system of justice with different procedures, a different penalty structure, and a different philosophy of rehabilitation. We play a cruel joke on our children by arguing that the juvenile system is a non-adversary, non-criminal, beneficent instrument of rehabilitation when determination whether criminal procedures are to be required at trial. While at the same time maintaining that it is just another criminal court when determining the procedures which must accompany waiver. It will not do to minimize or ignore consequences of the decision reached today. After a decision today, there will be many impressionable 16 and 17-year-olds who will be packed off to adult prisons where they will serve their time with hardened criminals. These children will be sentenced, moreover, without any meaningful inquiry into the possibility of rehabilitation through humane juvenile disposition. Perhaps I should add that I harbor no illusions as to the efficacy of our juvenile court system, nor do I believe that a fair and constitutional waiver system would rescue from the clutches of adult punishment every juvenile capable of rehabilitation in a more, not every little part of the notes, but only the note headers to conclude this section, legislative offense exclusion. So in notes number 1, offender versus offense is discussed. And really just brings up all the points of the case. Note number 2, judicial reluctance to review prosecutors' charging decisions. That also was one that the court grappled with, as you heard. Prosecutorial discretion, that is. They talk within that note about the United States versus Armstrong. Wow, there's a lot of other cases, I suppose, that go into prosecutorial discretion of perhaps the place in which, or the court in that has jurisdiction. There's Euler versus Bowles, Waite versus United States versus Armstrong. So there's 3. And Borden, Kircher versus Hayes. So this is all, I guess, on prosecutorial discretion of jurisdiction. Giving some of the court's language. Note number 3, excluded offenses and conviction of lesser not. The note quickly starts discussing State versus Morales. This was a murder, first-degree murder, within this note. So they concluded there is a conceivable rational basis for treating differently those juveniles who are convicted by a jury of manslaughter after being transferred to a regular criminal docket to stand for trial for murder, and those who are judged delinquent on the basis of a court's initial finding that the juvenile was engaged in conduct amounting only to manslaughter. We conclude, however, that even if we assume that the two categories of offender identified by the defendant, example, children charged with murder and those charged only with manslaughter, are similarly situated with respect to the statute, there is more than adequate rational basis for treating them differently. So that's kind of where they arrive. But they're talking about convictions at this point because the jury decided rather the process. So in State versus Beal, a Minnesota 1987 case, you've got the grand jury indictment coming in. Same thing, manslaughter, murder. We hold, so here's their holding, no person, regardless of age, has a fundamental right to juvenile adjudication, which necessarily would include a juvenile disposition. So, same issue. Consequently, the statute's automatic imposition of a district court sentence on the basis of an enumerated charge would violate substantive due process rights only if it is not a reasonable means to a permissive object. So, one would think that these notes are really establishing a shift further in the direction of the Bland case. So, legislative checks. So, note 4, legislative checks on prosecutorial overcharging. And they are talking about Beal and Morales, which we just discussed. Because it's charged for convictions. And they can get them into adult court if they overcharge, basically. So note 5, reverse waiver hearing. One statutory method to check prosecutors. After getting through that, there's a section within note 5 called automatic rejuvenation. If a jury convicts a youth of a lesser non-excluded offense, what is the justification? As in the Illinois statute for conducting a reverse waiver hearing, shouldn't the statute consistently with the rationale of offense exclusion simply provide that if a child is found not guilty of a charge for which he has transferred or any lesser included but excluded offenses, that the child shall resume his status as a juvenile for purpose. That's what you're expecting from this proceeding. And then People versus A.T. Jr. kind of, I guess, answers that question. That's the last paragraph of the notes. We believe that the courts can best fulfill their duties with respect to minors if they are allowed to make a new minor's case should be returned to the juvenile court for disposition or retained in criminal court for sentencing after a minor whose case has been transferred to criminal court is found guilty only of an offense or